talking about each of these types of leaves in more detail as we go along. But additionally, the other really important component of the PFML program is the job protection aspect. And what this means is that when an employee takes a leave and they come back to work, they need to come back to a job that is either the same job that they left or one that is equivalent in terms of pay status and benefits, length of service credits, and seniority. So this is something that doesn't get addressed or talked about quite as often as the income benefits, but provides protection for employees when they go out on leave. Next slide, please. One of the questions that we get quite often is, how is PFML different than FMLA? Well, first of all, FMLA is a federal law, and it only applies to businesses that have 50 employees or more. So FMLA is not available to smaller employer or employees that work for smaller employers. And there are different eligibility requirements where an employee needs to work for an employer for 12 months and needs to have 1,250 hours worked. For FMLA, it is an unpaid program, so there are no contributions that the employer needs to make. And it does offer, however, similar job protection. It's not exactly the same. There are some differences, but the program is about the job protection that is afforded through those benefits. And then PFML is a state law, and it applies to all employers. There are a few exceptions. Municipal employees, for example, are exempted under the statute, but a municipality has the ability to opt into the program. There are a number of other categories of employers that are exempt, and you can find that information on the website. But for the most part, all employers are participating in this program. In terms of eligibility, we really follow the statute for the Department of Unemployment Assistance. And so DUA has the requirement that you have to have earned $5,400 and 30 times the benefit amount in the past 4 quarters. So it is not necessary for an employee to have been with an employer for a specific length of time, provided that they met the income requirements in a previous position. So this is an important distinction. I should also mention here that employees are eligible for assistance for 26 weeks post-separation from an employer. So if they are unemployed, they do have the ability to apply to the program to receive benefits. So those are some pretty significant differences in terms of eligibility. And then in terms of the employer's role, the employer is responsible for collecting and submitting contributions on behalf of their employees. So you probably noticed that about a year or so ago, we started taking out contributions for the program, and the employer submits that, and if they're a size of 25 employees or more, then they also make a contribution towards the program. This program is self-funding, so there is a trust fund, and these contributions go into the trust fund and give us the ability to extend the benefits. As far as PFML, as I mentioned, job protection benefits are a major component of the program, and there are some differences in terms of job protection for PFML, so please take note of that. But again, it is a 2-pronged program and offers paid benefits, whereas FMLA does not. There's one other difference that I'd just like to point out here as well, and that has to do with caring leave specifically. And if you are taking leave to take care of a relative, the list of eligible relatives is different than it is for FMLA. The Massachusetts statute is a little bit more expansive, and we're going to talk about that later, but that is also another difference between these programs. Next slide. Just thought it might be interesting for you all to know what we've been doing since we started issuing benefits back in January. We have approved 162,000 claims, and we have paid out about $156 million in benefits. And the types of leave that have been provided, it's pretty well evenly split between medical leave and family leave. So we're going to talk a little bit more about that, but we started out pretty strong on the family leave component because people could take leaves for to bond with a child that had either been born or adopted or placed into a home within the past 12 months. So we had a little bit of catch up there, and now the medical leave claims are increasing so that we're at about an equal distribution there. So as you can see, we've been very busy since January 1st when we started issuing benefit payments. So let's talk about the leave types that are available under PFML. As our name indicates, there is family leave and there is medical leave. Medical leave is probably the most straightforward of the leave types. This is leave that is granted for you to take care of your own serious medical health condition, and you can receive benefits for up to 20 weeks to take care of your own serious medical health condition. And then we have family leave, and this is a little bit more complicated because there are 3 different aspects of it. Family leave can be taken for a duration of up to 12 weeks, and you can take that time to either bond with a child that has come into your home, either through birth, adoption, or foster care placement. And as I mentioned earlier, leave can be taken anytime within the child's first year of life or the first year of residing in the home. So that's an important type of leave that we've offered that has been utilized pretty heavily, particularly in the beginning months of the program. And there's also leave for active duty. And this is leave that is granted in order for family members to manage the affairs of a household where a family member has been deployed on active duty or has been notified of a deployment. So it would help that family to prepare for the family member to be deployed in the armed services. And again, this is a benefit that is available for up to 12 weeks. And then lastly, caring leave, which is the focus of our conversation today, that is also available for up to 12 weeks, and that is to allow an employee to take care of a family member who has a serious health condition. So that's going to be the focus of our discussion today. But what's important for you to note here is that if you have taken PFML leave that falls under the family leave category already, then that affects your ability to take additional types of leave under family leave. So if you've taken 12 weeks to bond with a child, then that has used up your allotment for this benefit year. So we're going to talk some more about this as we go along, but just be mindful of the fact that there are 12 weeks maximum for any kind of family leave. If you took some other sort of a leave, though, something that was not a PFML program, then that does not count towards the 12-week allocation. So little bit of detail there that you need to pay attention to. I'm going to open this up to the other participants from the department. Anybody want to add anything there on leave types? Did I skip anything? All right, hearing nothing, we'll proceed. Oh wait, one more thing. I just do want to mention again that the most leave that you can take is 26 weeks in a benefit year. And a benefit year is not a calendar year. It is based on when you take your first leave. So it's actually the Sunday that precedes the first day of your leave that you take. So if you started a leave in July, then that's when your benefit year begins. Next slide, Johan. So let's talk about proof of identity. This is one of the things that an applicant needs to demonstrate in order for us to approve benefits. And so we have an extensive list here of documentation that could be used in order to prove your identity, but I'm going to give you a little tip here. The easiest way to prove your identity is to use your Massachusetts driver's license or your ID card. And if you are able to use that, then you need to provide us with a copy of that, both front and back. I know it doesn't seem like that back is very important, but it is. We need to have both sides, and we need to receive copies in color. And there are certain file types that are acceptable, other ones that are not. So you do need to pay attention to what's required. But you know, a JPEG, which is your typical picture, is an acceptable format, and you can upload those documents through the portal, the claimant portal, where you fill out your application. So that's the easiest way of doing business with us. If you need to mail it in, then just be aware that it will take a little bit longer. And if you're in a hurry to get your claim approved, the best way to do that and get your application to the complete status is by sending us those files through the upload functionality. So we have a lot of detail that's available on our website regarding this. So I'm not going to take time talking about it here, but there is definitely an easy path here. So please utilize your driver's license whenever you can.
Larry, if I could just let folks know if the best way to submit your questions is through the Q&A. There should be a Q&A option either at the bottom or the top of your screen, depending where your menu is. So thank you.
Good to know. Thank you, Johan. I might have said the chat before, and the Q&A functionality is definitely a better way to do that. And again, if you want to ask your questions, we can answer them during the presentation, or we can have one of our team here jump on your question and get you an answer. So is there anything, Johan, so far that we should be addressing since we're taking a little pause?
Yeah, I mean, I have a few questions here. A quick one here is that, you know, just to clarify that bond and leave maximum is 12 weeks.
Right.
And then, but they are wondering if, you know, in what instance could I receive more than 12 weeks? And I think they're referring to when somebody combines medical with bonding as an extension. So I don't know, maybe we can give a little clarification on that part.
Sure. Yep. As I said, and I probably should have said a little more clearly, the maximum of leave that you can take is 26 weeks. So you can come up with any combination of family and medical that equals that 26 weeks. provided you don't exceed either the 12 weeks, right, for any sort of family care leave with the 20 weeks of medical. So we're going to look at some scenarios where for bonding, a mother adds on medical leave to take care of her recovery. And so that can either happen before the birth, if the mother is on bed rest or has some other considerations, or after birth. And so we're going to talk about that in a few minutes. But you can definitely combine those leave types.
Okay. If we have, if you like, I have some questions, a few questions that came in regarding job protection. I know that was a few slides back. Do you want to address this now, or should we wait till the end?
We could do that now. Paula, can you help us out with some job protection questions?
Sure.
So I can, yeah, so I can read off the question. This is a great example. So again, related to job protection. If, for example, my schedule is Monday, Wednesday, Friday when I go on leave, then once I return, the only opening is Tuesday, Thursday, Saturday for the same rate of pay, same seniority, and same benefits. Is employer allowed to offer me this option, or must they also return me to the same exact schedule?
So first off, thanks everyone for joining. I would say, although I am the general counsel for the department, I can't act and give legal advice. So this is a very fact specific, but I'll talk in generalities. So as your question indicated, you seem to understand, right? It's the same condition, status, pay. So that's what the law says. If there's an issue where you think your particular case, it somehow doesn't live up to what you think should be the equivalency, then it's a private right of action that you have. The agency is not involved in enforcing the job protection portion. It's a private right of action that you would bring to the courts. And so far, courts have not decided with regards to PFML, but they would likely point to FMLA case law, which is also similar job protections in terms of the equivalency of the position. If the union environment, I would also suggest you talk to your union reps about what is the equivalency at your workplace. But it's a bit more fact specific, but just the overall message to everybody is that it's a private right of action. And so it should be ideally, what you're satisfied with is being equivalent, but it could be an issue of fact, and that would have to be determined at the district court level.
Okay. Thank you, Paul.
All right, why don't we carry on, Johan, and then we can come back to more questions a little bit later. So I think we have some more information here on how you demonstrate your legal ability to live and work in the US. Again, color copies of a variety of documentation. Then as far as the proof of your social security number or your ITIN, you would need to provide copies of the following documents here. We've got the social security card, your W-2 form. So there are lots of different options here. A pay stub with your full name and social security number on it is acceptable as well. So a number of different options there for proving that item that is that requirement.
Yeah, and so this is if you don't have anything from the first list that we showed,
Right.
which is pretty extensive, which could be an out-of-state license or ID, a tribal ID, a variety of other things. So there's a link in the chat, or excuse me, in the Q&A that takes you there, but it's on the website.
Exactly. Thank you, Katie. And again, regardless of the option that you choose, need to have document copies that are front and back. They need to be in color, and they need to be saved in certain types of images. And if you do choose the mail-in option, we are not able to return documents. So just know that you should be sending in copies So please take that into account. So let's talk about the documents that are needed for bonding leave. When a family wants to spend time bonding with their newborn child, we do require some proof of the child's birth. And so one of the things that is acceptable is a copy of the government issued birth certificate or a statement from the child's healthcare provider stating the child's date of birth. You can also use a statement from your healthcare provider if you are the mother of the child. And sometimes hospitals will give out a statement or birth record, and that is an acceptable document to use as well. And if you have a child that you have adopted or has been placed in foster care, again, we do need to have some proof of that placement or the adoption. So we've got some of the options that are available for that as well. And just as a reminder, we are going to be providing you with all of these details with a copy of the deck. I should also point out that we have a number of resources that are on our website. One is an employee toolkit, and actually some of these slides come from that toolkit. So you'll find that it is streamlined and provides you with the information that you need as an employee to apply for benefits. We also do have a toolkit available for employers, and again, that streamlines the information and gives them just exactly what they need to know. And then lastly, we have a toolkit for medical providers as well. So you'll be able to find this information either in one of the toolkits on our web pages or through this copy of the presentation that we're going to distribute. So again, let's talk about documents. Documents needed for family caring leave. So this, as you recall, is the leave where you need to take care of a family member who has a serious health condition. And so here we have a certification form that we require. And so that is a form that you will need to complete some of the information, but most of the information is going to be provided by the healthcare provider for the individual who has the health condition. So some of the things that we ask for on that statement is whether they have a serious health condition and when that condition began, and that you are needed to take care of that family member. They'll ask for some examples of what that care might look like. They will also ask for, or we will also ask for information on how often and how long you might be needed to take care of this family member. And then most importantly, we're going to be asking for the name and address of the family member and their relationship to you. So you provide an attestation at the end of the application that the information you have provided is accurate. And so this is the type of information that you should be prepared to either provide yourself or have the healthcare provider perform or provide for us. Thank you. Okay, next slide, please. Now, these are the documents that are required for medical leave. And again, this is the leave type that's available for you to take care of your own serious health condition. And so in order to approve leave requests for this type of leave, we need a certification of your own serious health condition. And we will also accept FMLA certification of a healthcare provider for employees serious health condition. Oof, we need some shortened nicknames for these forms. They're it's long and involved for sure. But these forms are available on our website. You need to have the form filled out by your healthcare provider. And again, they're going to ask for, or we're going to ask for information that demonstrates that you do have a serious health condition, a certification that you can't work as a result of your condition, the probable duration of the condition, and a statement about why the schedule is needed. And then the date on which your condition started. So these are the types of things that you should be prepared to have your healthcare provider answer on your behalf. Next slide. Okay, let's talk about the application process. The first thing that is involved is creating an account. You should go in and create your own account and prepare to apply for benefits after you've had a conversation with your employer. That connection with your employer is really, really critical. We want to make sure that your employer is on board with what is happening, that they're aware that you're applying for benefits, so that they can respond quickly when their part of the process comes into play, and they can help you to go through the different types of leaves that are available and look at which one is most advantageous given your own individual circumstances. So again, I think we know that some medical conditions are ones that you can anticipate, and some are ones that you can't. And so what we're looking for in your conversations with the employer is a best guess in terms of start dates, and those details can always be fine-tuned, but we would like for conversations to start with employers 30 days before you intend to take the leave, and that would be in the circumstance of a planned medical event, if you're going to have a child, or if you have planned surgery that's upcoming. We understand that those conversations can't happen with that same degree of advance notification if it's for an unplanned event, and we just ask that you contact your employer as soon as you possibly can if you encounter an unplanned event. So the next step after you have created your account, and again, this involves verifying your identity, and so you'll need to be prepared to upload those documents, and that's the next step here. So we want to make sure that you have all of that stuff ready to go, and if you don't, though, if you find that there is some documentation that you don't have, you can always come back and complete your application at a later date. So if you just want to go in and get a start, you can do that and then come back and provide the documentation as it becomes available. Next slide, Johan. So the next thing that you'll want to do is to select your leave details. And so this speaks to the type of leave that you're going to be taking, and the frequency or the schedule that you'll need. And so if you are going to be taking a leave that is intermittent, or if you work on a part-time basis, then that's something that you'll want to discuss with your employer. And but that's a question that you'll be asked is what type of leave, and what about the frequency. So the next step is uploading all of those forms that we talked about and entering your employment information. So again, you're going to be asked for your EIN, which is your employment identification number, And that's something that we need in order to process the claim. So you can get that off of your W-2 form, or you can ask your employer. Next slide, please. So another thing that you're going to want to have information about is any other assistance that you might be getting at the same time. If you've got unemployment insurance or sick time through your employer, workers' comp, paid time off, Social Security, that we may need information about school breaks or vacation time if you're in the education industry, and also any temporary disability or medical leave benefits that you get through your employer. So any other benefits that you are receiving, you need to report. And these can impact the amount of your payment depending on the type of benefit that you're receiving. So you are responsible for providing that additional information. This seems like something that our legal team might want to weigh in. Paula, do you have anything you want to add there?
No, thank you, unless there's a particular question.
All right. All right, let's keep rolling, Johan. Again, we're going to just draw on the information provided in the previous slide about any reductions. You are responsible for providing that information. So we ask that you have that available to you when you're preparing your application. And the last thing, most important thing, well, maybe not the most important thing, but a very important thing is your payment method. So you're going to tell us whether you would like to have a direct deposit into your bank account, or whether you would like to have a check issued. And it is certainly more expedient for you to choose the direct deposit route. And so you would need to give us your banking information so that we can get that set up for you in advance of your first payment. Next slide, Johan. All right, let's talk about what happens after you apply. So the department will not start processing your claim until you have submitted a complete application. And so you need to make sure that you have everything provided. All the forms are uploaded and all of the information completed. Once you do that, we're going to ask your employer to review your file. So they have 10 business days in which to respond. And so it's important that, that they are a part of the conversation before you even apply. We're going to give them a little nudge. We're going to send them an email and say, hey, there's a claim waiting for your review. But if you've already greased the skids and gone in and talked to them about the leave that you are going to need to take, that's going to help to speed things along, and you can certainly advocate for yourself in that way. So once the employer has had an opportunity to review the documentation, then we will review ourselves. We've got Dan Dakotas here who works on that end of the business and handles our appeals. Once we have sent out an approval notice or a denial, then we set up your payments for you. And that's the last step internally before your payments are actually issued. So I think it's important for you to note that there is no payment for the first week of leave. There is a 7-day waiting period, and payments are made on a weekly basis. One of the questions we received the other day, Dan, was about the appeals process and what happens if something was misinterpreted or a claim was denied when the claimant feels it should have been approved, what happens then? Can you give us a little more information about the appeals process?
Yeah, absolutely. If you're denied for any reason, you have the right to appeal. You can do that online. It's very easy to do and free. You could also mail or fax to our contact center, and we'll file the appeal for you. Once we receive your appeal, a member of my team will call you in about 2 weeks. We will try to resolve whatever the reason was for a denial. If it was, for some reason an identification document failed, or the certification form was insufficient, or whatever the issue is, we'll identify that, reach out to you, and try our best to resolve it. If it's, hopefully something we can clear up simply. If so, and we can approve it, we will do that. If for any reason, we're unable to get it to an approved status, we will send that off to a hearing, which anyone denied has the right to a full hearing under Mass General Laws, Chapter 30A, and regulations thereunder. You can be represented, bring witnesses, submit additional documentation, and you would be, we do a video hearing at the moment that's recorded, and you'll have the opportunity to present your case in full. And if after the hearing, we still have the power to overturn that decision and make you eligible. And again, if just even after hearing that's not possible, we'll issue a decision affirming the denial, which you have further appeal rights to district court.
Great, thank you, Dan. One thing that should note also, the employer reviews the information, and when on this slide here it says that they approve, we are actually the ones that make the decision about whether benefits are issued or not. The only way that an employer can deny a claim is in the case of an intermittent leave request. And so that's a situation where you need to work out an intermittent schedule that might work for both parties. So, and that might be an example, Dan, correct me if I'm wrong, but that might be an example of something that would wind up in appeals or further discussion with the department. But if you're going out full-time, the employer does not have the right or the ability to object to that.
Yeah, Marion, I'm sorry. I was trying to answer a question in the chat, so I think I missed the first part. But we do take certain information from the employer, and based on that, it could result in that initial denial. And then on appeal, again, my team will reach out and take further statements and try to resolve, whatever it is.
Great, thanks, Dan. Johan, how about the next slide? All right, I think we're going to pause here for just a second and see if we can answer some of the questions that have come in. Johan, do you want to feed us some questions?
Yeah, let's start with some basic questions here about clarifying bonding leave. One question that's come up a few times is, if I take bonding leave, will that reduce the time that I have for family leave to care for a loved one?
Yes. Yes, the answer is yes. There's a 12-week maximum for any type of family leave. So caring and bonding are in that same bucket, as is the active military component of the program. So you can come up with any kind of a combination of those programs to get to the 12 weeks. But once you've hit that during the benefit year, that maxes you out.
Okay. Now, we'll continue with bonding leave here. So a question that I was hoping to clarify if the father of the child and the mother of the child could both take leave, bonding leave. That's question number one. Question number two is, if so, do they need to take it at the same time, or can they take it sequentially? What are the requirements there?
Yeah, that's a great question. Yes, both parents are eligible for leave, and it's up to them to determine whether they take it at the same time or they take it separately. And in some cases, somebody might take leave for the mornings, and somebody might take leave for the afternoons. any way you want to put it together is okay with us.
Okay. Switching gears a little bit here, talking about family members. There's a few questions asking to clarify what a family member is. I think we're going to go over that in the next slides.
Yeah.
There's also there's also more information on the website, and I think Katie will also be going over that link.
All right. Well, why don't we talk about combining types of leave, because that seems to be on the minds of folks that are taking part here. So we're looking at, or the question is whether you can combine different types of leave, and the answer is yes. And I think the most relevant and prevalent, I guess is the word I'm trying to use, example is for a mother, an expectant mother, and they're planning to take time off to bond with their child, but they may also have some of their own medical needs. And so if this is your scenario, what we would encourage you to do is to fill out the certification of your serious health condition form, take it to your doctor, and have them complete that for you. Again, as I referenced earlier, there are situations where someone might need to have bed rest or some care prior to the birth of the child. And in other cases, it's for situations that arise after the birth of a child. So you can combine those leaves. In this case, it's a lot easier for you to go ahead and line up to get that medical leave component in place, and then you can add the bonding leave to that. In that situation, there would not be a second waiting period. And the contact center can be very helpful to you in helping you with the documentation that you need in order to get that bonding leave portion activated. Are there any questions about that or any comments that our team wants to make?
I do have.
Again, in this situation, would be a maximum of the 26 weeks. So depends on the circumstances, but you can combine medical with bonding. All right, next slide. So this is something that we've touched on already, but I'll just quickly reiterate that we do have different types of leave schedules. You can take a continuous leave. So that would be a single time period that is uninterrupted. So, if you have 12 weeks of bonding that you want to take, you can take, January, August, September. Oh, no, that's wrong. Sorry, I think I've had a little too much caffeine. You can take January, February, March continuous time. So excuse my error there. You can also take reduced leave. So this would be a consistent schedule, but reduced for multiple weeks. So again, back to a scenario where you might just want to take mornings off. You can work that out with your employer for reduced leave. And then intermittent is where you're going to have multiple episodes of time that you need to take off, but it might be that it's irregular or unexpected. And that type of leave is one where you do need to be reporting back to PFML on the schedule of your leave, how much time you've taken on a regular basis. Next slide, Johan. Combining leave schedules. I just looked at the clock and boy, time's a flying here. So I'm going to go quickly through this. I think that the point here is that you can adjust the leave schedule that you set up. If you start out with a continuous leave and then you want to go down and kind of stage your comeback into your employer and you want to work part-time going back in, you can do that. And that particular scenario can be combined all in one application. If you want to take reduced leave, and in this circumstance that's described, Jose is receiving radiation, he can take a reduced leave and then also transition to an intermittent leave if he needs to take time off, but you're not really sure when that time is going to be. So if you're using reduced and intermittent leave, then you have to create two different applications for the leave. So you know, if you have a scenario that you're not quite sure whether you'd need two applications or not, that's certainly something you can call the contact center about, and they can advise you on how you would apply. Roles and responsibilities. Wow, we have a lot of ground to cover still, so I'm going to go very quickly. Next slide, please. We've talked a lot already about what the employee's role is, but we've got 3 bullets here discussing the leave request with your employer. That's really important for you to do before you start your application. It's actually something that we ask about in the application. We asked you to give us the date that you had that conversation. And again, we ask that you give 30 days notice wherever possible, and that you provide accurate and complete documentation. Otherwise, your application is going to go into a stall pattern, and we cannot review it until it's considered complete. Next slide. The employer's role. The employer needs to have provided you with information about the program and the contributions that you make, and they are also responsible for displaying a workplace poster. They are also responsible for educating employees about PFML benefits, and so it should be a part of the deck of cards of benefits that are offered by the employer. And then again, discussing the employee's leave requests, the type of leave, the frequency, schedules, and any other factors that might come into play. And the employer, again, reviews information like your wages, any other information that's provided in the application, and they have 10 days to provide us with additional information. So this really ensures that you get the correct payment amount and that you get the duration that you're looking for. And so we want to make sure that they provide a double check on any other leaves that might have been taken during that benefit year. And lastly, the healthcare provider's role. They play a really important role in giving patients and their families information about the program right at the point of care, right and when and where they need it. They help patients and their families understand how the benefits can help with their recovery and their family's health. And then they provide that necessary certification or documentation to demonstrate a serious medical condition. Katie, do you want to take over for a little bit here? Take the wheel?
Sure. Okay, so I'll go quickly as well. So we just want to go quickly over what's new for family leave to care for a family member. So a lot of people already asked about this, and I did put the link in the chat, I believe, and we'll send it out as well. But this is for the for purposes of leave to care for a family member. This is the list of eligible family members. We do go into more depth on the website to give you a more complete list. We say, you know, adopted, foster, through legal guardianship, on all the different types of relationships you can have, but this is the master list. As we've mentioned earlier, family leave is an umbrella, and it consists of bonding, family leave to care for a family member, and also to manage the affairs of a covered service member. So if you have taken any other types of family leave under PFML, it will count towards reducing your 12-week allotment. If you took family leave under another program to care for a family member who has a serious health condition, it does not count. So again, what you've taken under PFML under family leave will count towards the 12-week allotment for the benefit year. These are just a list of activities that obviously it's far from exhaustive, but we wanted to give people a flavor of what we were thinking of. There's the very obvious daily living needs that we might need to provide, something like putting meals together, getting them dressed, getting them prescriptions, but also obviously providing transportation to the doctor or appointments, providing mental health or psychological support for their serious health conditions, such as taking them to therapy or getting them medication for chronic depression. We bring this up because a lot of serious health conditions like diabetes do have a mental health component, and mental health is part of it. Helping make arrangements for changes in care is another part, which is such as the transfer to a nursing home or another facility. Next slide. Okay, so this is the main thing that you need to submit as part of your application. Obviously, there's proving your identity and all the other types of pieces of information we've said, but this is the major form. So a certification of your family's serious health condition form. You can download that from the site today. It's in multiple places, and you will need it to fill out the first part, and then your healthcare provider will fill out the rest. Oh, excuse me, your family member's healthcare provider. So next slide. This is what
Katie, I'm just going to drop in for just 1 second here. One of the things we haven't talked about with caring leave is the fact that the family member does not need to live in Massachusetts. So the family member can live, you know, in Arkansas, they can live where they could live in Guam, they could live anywhere, not limited to the United States. Just keep that in mind.
Thank you, Mary. So this is what you would fill out as the employee. You have to give your name, address, other contact information, the last 4 digits of your social security, and what leave you're applying for. Next slide. This is where you would enter your family member's information. You just check off what the relationship is. There's a link right there in the gray box to the right with the larger list that I just talked to you about, and then your family member's name. Next slide. And then you give them your address. As Mary mentioned, and it's also in the instructions to the right, they do not have to reside in the state of Massachusetts or the country of the US. You have to be eligible for the leave to take care of them, but they do not have to live in Massachusetts or the US. And then we ask you for the family member's date of birth, and then you sign the certification form. By signing the form, and you'll see that in the language, you're attesting that everything that you put on the form, the information is as true as you can believe it, it's accurate to the best of your knowledge. Then you would basically need to get this form to the family member's their healthcare provider, because they're going to need to fill out the rest to attest to the family member's serious health condition, some sort of information around that, and why they need help from you. I think we're at the Q&A part, yep.
Well done. Thank you, Katie. So we are happy to stay and field some more questions, but in the event that you do need to jump, we understand. We want to give you some resources. You can contact our contact center at 833-344-PFML or 7365. And they're open Monday through Friday from 8 a.m. to 5 p.m. And we have multilingual agents that are there. They can provide you with assistance if English is not your primary language. We also have the DOR contact center, and they can help you with questions about contributions or exemptions. And the primary source of information on the program is our website, mass.gov/PFML. So those three resources are there for you to answer your questions. But we're happy to continue on and answer questions for folks who can stay. Johan, do you want to feed us a few questions here? I don't know if there are any ones that I think Paula may be joining or leaving us shortly. So I don't know if there are any that would require her expertise.
Well, Lisa's been fantastic in answering a lot of them as well. So
Awesome.
Uh,
I know
I
there's
guess-
one. Hold on, I think there's one that Paula might be able to shed some light on. And I've gotten this question before. It's whether job protection is provided while a case has been denied and is an appeal. I think that's a good one.
That is a good one.
Sure. So yeah, thank you. Job protection is again a private right of action. And so while it's an appeal, that's again, sorry to say this, a typical lawyer, so I'm sure you're not surprised. It all depends. Depends upon the specific facts, right? So if I was an employer, I would tread carefully. If I was an employee, I would not pretend to have a magic force field. I think, as most things, to be reasonable, to communicate with your employer, you need to follow your typical employer protocols for any time you're out on leave, right? Because it could also be the case that they have their own policies in place separate from PFML, and possibly FMLA is implicated. So it's complicated just to answer that in the abstract. And in the end, frankly, it wouldn't be the department, it would be a private right of action in court. So I'm not in a position to not only give legal advice, unfortunately, to constituents, but also it's a position that the DFML we have not encountered yet, so we have no court opinions to rely on. And it is not DFML's statutory role to play. We're actually explicitly excluded from it in the statute. It's a private right of action in court. So I wouldn't try to overstep my bounds there. So that's sort of my answer for the time being. As policy, et cetera, we'll, obviously watch this closely, and we're interested in it as well. But the basic answer is there's no magic wand here about job protections. It's very fact specific, and in the end will be a private right of action in court.
Johan, what other questions can we answer for folks?
Yeah, I see a few questions again. I think it was a popular one that comes up regarding what if I have PTO, what if I take FMLA, or what if I take short-term disability? Essentially, how does PFML benefits interact with other benefits, and what is the correct way on to use them in combination if that's the case?
Right. I see that there's a question too about the duration of the benefits and asking if you only get paid for 11 weeks out of 12, which is true. A lot of people might want to use PTO for that 7-day waiting period, and that is a scenario that is allowed. But Lisa or Paula, do you want to respond about the combination of benefits?
Yeah, I saw that question coming up a lot. You're free to use, well, two scenarios. I saw a bunch of questions, and I've fielded this question before. If your employer provides some sort of benefit where you can get 100% of your wages for 12 weeks of bonding, you do not need to file with us. You would still have job protections. In any scenario where you're going to file for leave with the Department of Family Medical Leave, and you would receive $0 from us because you are going to be receiving other income from another platform or the use of your own time for the entire duration of the leave, you do not need to file an application with us, and you would still be allotted job protection. It's clear in our regulations about that. But if you want to take, let's say, a split, so I want to take 12 weeks of bonding, but I have enough accrued time that I want to get, I want to use 6 weeks of my own time because I can get my full wages, and then the remaining 6 weeks of PFML time, you can do that. When you apply with us, you indicate that the first 6 weeks you'll be paid 100%. Your employer will also indicate that, that you would be receiving wages from another source for the first 6 weeks. And then the remaining 6 weeks of your 12-week bonding will be paid by the PFML. So what we have seen are people use it in chunks of time, either the beginning or the end. And as Mary said, the first week is unpaid by PFML. So even though I said 12 weeks, you would only be eligible for 11 weeks of actual pay from PFML for the bonding. So the first week, because we don't pay you, you're allowed to use accrued paid time off. But the general rule is if you're going to use your own time or any other wage replacement for a day, you cannot also be paid for PFML on the same day. That's the rule. You can't stack benefits.
How about unemployment? Lisa, do you want to address that at all?
Unemployment, workman's comp, any of those, it's also a type of wage replacement. Those would be offsets. So if you're currently collecting $200 a week, let's say in unemployment, you have to report that. And then if you're eligible for leave during the same time, your benefit would be reduced by $200. So you can't receive, you can receive benefits at the same time for unemployment and workman's comp, but they would be reductions. So if you receive, another example, you are injured at work and you receive $1,200 a week for workman's comp, you would be eligible for nothing from us because the max we can pay out is $850. So if you're receiving benefits of any other sort, but it's under $850, you may possibly be still eligible for a portion of our benefit, but that doesn't mean it's necessarily a guarantee because again, you could apply and your financial eligibility may only render you eligible for $500. So if you're only eligible for $500 from PFML and you're receiving $600 in unemployment, you would be receiving $0 from us. It depends how the math works out. So like Paula said, it's difficult to, I'm just answering in hypotheticals at this point.
That's right. That's all we can do here.
Yeah.
But again, I think it is important. We haven't mentioned that the maximum benefit is $850 per week, and that is something that is set by the statute and readdressed every year. So, but for now, that is the max. Let's see if we can take a couple more questions, and then we'll let folks get back to work. Johan, what else do you see?
Sure. I think bond and leave has been a very popular topic today. So for example, if I apply for family leave for child bonding and only use 4 weeks initially, and later in the benefit year I need to take another 4 weeks for alternating with partners, would I need to file another claim for the second 4 weeks? Or can I just extend what I already filed earlier in the benefit year?
I think it depends on what the gap is between, but Lisa, do you want to address that one?
Sorry, I didn't catch it. And I also wasn't on mute, so I apologize if you heard me typing, but I didn't catch the question.
Yeah, the question is, the question is if I take 4 weeks for bond and leave now, and then decide to take an additional 4 weeks later in the benefit year, do I need to submit a new claim for that second part, if you will?
Yes, because it's not considered an extension if the last day of leave has already passed, if it's not back to back. Also in that scenario, because you're taking it in 2 chunks, your employer, depending on the policies of the employer, may consider it one big intermittent leave. And you need to make sure that you clear that under the policies of your employer, because intermittent bonding leave is one of the leave types in our regulations. We specifically require employer approval for it. So if there's a policy that you cannot do that at your work, you may not be allowed to do it. It might be denied. But other employers allow it. They don't consider it intermittent, and you can take it in 2 chunks because you would be able to to do it if it's within 12 months of the birth of the child, but it all depends on your employer policy. So I would caution you to make sure your employer is okay with it and you can proceed, but it would be up to the employer, I would say.
So Lisa, let's talk about extensions for a minute. I think that might be a topic that's important to people. If somebody decides to take 4 weeks and then they want to extend it, if they notify us within 14 days of the expiration of the leave, they do have the ability to extend, right?
Correct. Yes. And that is clear in our regulations. I know that if, let's say, the leave has ended and a month goes by and you need to take leave off again for the same reason, you would incur a second 7-day waiting period. It would be considered a second separate leave. So only if it is a true extension would there be no second 7-day waiting period. We've seen scenarios of those. So, try to make sure that employees coordinate with their medical providers. And if you're an employee, make sure you allot yourself enough time before the last day of your leave if you feel that you would be needing an extension to go to your doctor and get the appropriate paperwork. If that is not feasible, call our call center and indicate that you would be looking to file for an extension as a placeholder in order to get that extension filed timely. And then you can come back and file the paperwork. It'll just remain pending as an extension application on your record, but it'll keep the record open. And you can submit your paperwork afterward to support the claim, because if you file after the last day of your leave, you might be locked out and it might incur a second 7-day waiting period.
Okay, good to know. Good to know. So we have a couple questions in here about the employer's role and what happens if they don't respond. And the employer has 10 business days to respond. That's their timeline that they've got to review the information that is there and respond. And if they don't respond within that timeline, then the department makes the decision based on the information that is provided. So if employers want to have a say-so in what is reviewed, then they need to stay on top of this, but it will not delay the timeline for approval. But if they're on top of it and they get it done right away, it can shorten the approval time. Let's see if we can take 1 or 2 more and then we'll call it a day.
All right, let's see here. Can my employer deny a request for reduced leave?
Lisa, you want to take that one, or?
I'm sorry, can you repeat that? I'm not having good luck with audio right now.
Yeah, no worries. The question is if the employer is able to deny someone that is applying for reduced leave.
So in the response, when an employer is paying to review an application and respond, you have the ability to tell us what your determination is. If you have approved the leave, if you're denying the leave, or if the leave is pending, and you can write in exactly why your rationale for any of the above. Like I said before, with intermittent bonding, that is one that employees are free to make policies that do not allow it for their business purposes. In terms of any other reason, if you check off that you're denying the claim and you put in your response as to why, it'll be taken into consideration. But a flat out denial, I cannot say would be a flat out denial by the department. The department takes the employer's decision as a consideration in adjudicating the claim. But again, if an employer, not that this is just a crazy hypothetical, but an employer says, I'm denying the claim because the employee always wears brown shoes to work, we cannot deny that claim on a rational basis. So that claim would be approved if everything else checks out. So again, it is something that is considered in the department's final determination to pay benefits, but it is not the end all be all. It does not necessarily mean that the department will deny it.
Well, we're almost a half an hour over here. So I think let's conclude our session for today. Again, if we didn't have a chance to answer your question, we will be putting together some FAQs that address those unanswered questions. And please do contact our contact center. Their number is 833-344-7365. They're open Monday through Friday from 8 until 5. I want to thank all of our panelists today. Thank you all for being here. Just a reminder that the information will be up on the website, and we'll be sending you a short survey. Don't discard it because it's going to have the links to the deck and the audio version of this. And we're going to be working with Marissa to get this and other tools translated into Spanish and Portuguese. So please do check back, bookmark our webpage, and we thank you very much for your participation today. Have a great 4th of July, everyone.
Thank you.